Some people have been asking in the comments section how it is that a claimant might ask for damages in respect of alleged phone hacking for events that they had no knowledge of. But of course, having knowledge of the events is very much one of the key arguments in this case. Indeed, Mirror Group newspapers last year tried to get this case thrown out on the basis that the claims were brought too late. But the counter-argument to that, which has been put forward by David Sherborne for the claimants today, is that these claimants may not have had knowledge and awareness of these articles being published until more recently, and therefore the claims are not brought out of time. So to discuss that in a little bit more detail, I'm going to talk a little bit about what's happened today in court and what key witnesses are saying today. Stay tuned. So welcome back to the channel. So today I'm going to talk about what David Sherborne is questioning, and specifically Dave King today. Because we take a look at the Sky News article, which has been given a fantastic coverage of this so far. David Sherborne, pictured here, questioning Dave King on the attention that people give to either online or in-print news articles, and specifically those that include the terms phone hacking. He's accusing, essentially, MGN's solicitors of artificially inflating the number of articles about phone hacking claims against the group. Now, the reason that he's doing this is because David Sherborne, of course, wants to argue that some of these claimants may not have been aware of these articles, and that if the group says that there were lots and lots of these articles all about phone hacking, that they must have been aware of them. David Sherborne is obviously arguing that if this number were inflated, and in fact there weren't quite as many articles about phone hacking to bring this to the attention of the claimants in the case, then they probably would not have been aware of it. And so he's doing this to demonstrate that his clients, the claimants' claims, have not been brought too late. You see, under normal rules, you have a 6-year time limitation for simple contracts and torts and various other things. And if your claim is brought beyond that date, then ordinarily it's out of time, it's statute barred. But if you can show that you only had knowledge of those events more recently, then that time limit can be disapplied. But there's a fairly stringent test. And so that has been argued and agreed by the judge in this case. Moving back to the article, as it says, last year, Mr. Justice Fancourt had said that these claimants should be allowed to prove that they weren't aware of phone hacking at this trial, and therefore the case is valid. But going back a little bit further to yesterday, or reports of yesterday, about what Dave King had said in respect of Mirror Group in the beginning of his evidence. First of all, for context, Mr. King is the founder and chief exec of Digitalis, quoted as an online advisory firm providing a range of advisory services relating to the internet, a fairly broad internet advisory service. In his witness statement, as reported by Sky News, it explains that he was instructed by MGN solicitors to carry out a search of all print newspaper articles published between 1st of December 2012 and end of December 2016 for the term phone hacking. This is the period when these allegations of prolific hacking at MGN came to light, and including arrests of MGN journalists in 2013, an admission by the group in 2014, and a public apology to some victims in 2015. Not forgetting, of course, the BBC coverage of Hugh Grant settling his claim against the Mirror Group, which was reported to be on an industrial scale. And you can read about that from the BBC in 2018. So moving back to the Sky News article, it says originally, when MGN wanted some of the claims in this case to be struck out as the normal 6-year time limit elapsed. But as it says here, Mr. Justice Fancourt ruled last year that although there was considerable coverage of the scale and nature of phone hacking at the group in 2014, he said each of the claimants in different terms explains that in their witness statements that they were not attentive to print or television or radio news media, which they've reiterated in court this week. Going back to what David Sherborne is asking, David Sherborne for the claimants, questioning Dave King for the Mirror Group. David Sherborne asked Dave King whether he was paid by MGN solicitors, RCP, to provide the analysis of news articles covering the phone hacking. He says he was, and confirms that he's not an independent witness. An independent witness would be obviously someone that has no connection to either party. Asked how much, Mr. King says it's not yet clear as he's still giving evidence, but his organisation, Digitalis, has charged in the region of £30,000 to £40,000 so far. So just to be clear, the group, he says, has paid £30,000 to £40,000 so far for him to be providing this evidence with regard to phone hacking. Dave King goes on to say that his firm Digitalis analysed news articles containing the term phone hacking between 2012 and 2016, which brought back more than 19,000 results from UK media. Obviously, this is quite the large sum, and there was an exchange with the judge here where the judge said that it must have been quite interesting. In fact, slightly further up here, Mr. Justice Fancourt asks for clarity about the instructions given to Mr. King. He replies that the search took the form of a lot of human hours. The judge jokes with a smile that the analysis of more than 19,000 articles must have been quite interesting. And context given by Sky News here is that, of course, David Sherborne is arguing that they have valid claims because they might reasonably not have been aware of the allegations of the phone hacking at the Mirror Group in recent years. And yet the lawyers for the group argue that the claimants have left it too late to submit their cases. So this argument goes back and forth. But just to reiterate, in a sense, that a lot of this has been admitted previously with other people in other situations, and the group is simply saying that in these cases, it hasn't all happened in the way that they said it had. But this case and these claimants are arguing about a specific set of articles and specific sets of allegations of phone hacking in respect of those specific articles. Now, many people might ask, well, how does that give rise to damages if they weren't upset and distressed by publication of those articles, if they weren't aware of the articles? Very good question, which I've seen multiple times in the comment section. So I thought I would address that in this video. Now, there are civil penalties available for a wide range of different types of breach of data protection and rights and confidence. And so, broadly speaking, there's compensation and injunctive relief. That is a court saying, don't do this and don't do that, or you must do this or that. And the compensation in the form of damages, i.e. money, can arise out of a breach of confidence. That is, if there is a confidence between two people not to disclose information to third parties, and yet it happens anyway. A breach of the right to privacy, that's under Article 8 of the Human Rights Act. The misuse of private information, that can mean if you have someone's private information, whether it's lawfully or unlawfully, but you use it in a way that is wrong, that could be a misuse of that private information. A breach of data protection, that applies predominantly to organizations, but it can very narrowly apply to individuals, but predominantly to organizations or those acting in the course of business. If they gather, process, and disseminate or otherwise store, use, manipulate information of an individual that is identifiable in a way that is not in accordance with the rule, that could give rise to a breach of data protection. That includes the breach of said data or unlawful gathering and things like that. And damages can arise as a result of that. And on the outskirts, you could talk about copyright infringement and also all sorts of other things, because there is a copyright in anything that is committed to a permanent format. So infringement to personal information, the loss of control of that personal information, obviously that can result in unwarranted media coverage, which even if you didn't have knowledge of it at the time, but you develop knowledge of it later, then the damages can still arise, even though the arguments for bringing the claim ordinarily out of time are going on because of the time lapse, but becoming aware of it later doesn't make it less wrong that it happened in the first place. And so obviously that can cause embarrassment, even if retrospectively. And of course, a person should have the right to enforce such a claim if indeed it's accepted, as it has been so far that they had no knowledge of it until after the event. So I hope that served as a brief overview of how those claimants might be bringing claims for damages, even though they may not have been aware of these articles at the time. That very much is part of the argument. The fact that they had no knowledge of these articles, as argued by David Sherborne in this case so far, means that the judge has allowed this claim to be brought and they are seeking those damages. As to the result of the case, we will have to wait and find out, of course. So the admissions are limited to what have been made so far, and the outcome of this case, I think, will be very interesting. So thank you for the question. Please keep those questions coming. I will endeavour to address those in further detail with further reference to the news reporting. Please do remember to like the video and subscribe and hit the notification bell. That really helps my channel grow, and I appreciate it. So thank you for that. And in the meantime, thank you for watching.